All right, let's dive into one of the most critical and honestly, one of the most misunderstood final steps in Philippine litigation, the appeal by certiorari under Rule 45. Now, if you're a law student buried in books for the bar, or you're already out there practicing, this is one rule you've absolutely got to master. So let's get right into it.
So picture this. A decision from the Court of Appeals, or maybe the Sandigan lands on your desk, and it is not what you wanted to see. It really feels like the end of the road. But what if there's just one last, very narrow path forward? The real question you have to ask yourself is, are you even allowed to take it? You know, the best way to think about Rule 45 is to imagine you're climbing a huge mountain. The Supreme Court, that's the summit, the absolute peak of our judicial system. And this isn't some casual weekend hike, okay? This is a steep, technical climb with incredibly strict rules you have to follow just to even get started. So here's our map for the climb. First, we'll set up base camp by figuring out what this final appeal really is. Then, we'll get into the most important rule of the climb, law only. After that, we're racing against a 15-day clock. And then we have to figure out how to prove our case is special. We'll also scout out all the fatal flaws to avoid, and we'll wrap it all up with a handy cheat sheet for the journey. Okay, let's start at the very bottom of the mountain. What exactly is this last chance for review? Well, Rule 45 gives us what's called an appeal by certiorari, and it is quite literally your last shot at getting a case heard by the highest court in the land.
The official name is a petition for review on certiorari. Section 1 tells us it's for appealing final judgments from places like the Court of Appeals, the Sandigan, or even the regional trial court in very specific situations. But I want you to look really closely at that last part, based only on questions of law. Honestly, that one phrase, that is the key to this entire climb.
And that brings us to the first, and I would argue, the toughest gatekeeper on this entire journey. If you don't get this next concept, your climb is over before it even begins. This is the absolute golden rule of Rule 45.
Let's really break this down. A question of fact asks what happened. You know, like, did the driver actually run the red light? To answer that, you have to look at evidence, weigh testimony. The Supreme Court does not want to do that all over again. A question of law, on the other hand, asks how does the law apply? So assuming the driver ran the light, does that specific act legally count as reckless imprudence? See the difference? That's about interpreting the law. Rule 45 is only for that second kind of question.
The reason for this is pretty simple, actually, and Section 1 of the rule spells it out. The Supreme Court is not a trier of facts. Its job isn't to re-examine all the evidence. For the most part, whatever the lower courts found as fact, well, that's considered final. Your entire mission in a Rule 45 petition is to convince the court that the lower court got the law wrong, not the facts.
Okay, so you've done the hard part. You're sure you have a pure question of law. Fantastic. Now you're up against your next big challenge, a very, very unforgiving clock. On this part of the climb, your timing and your paperwork are everything. One slip up and it can be fatal.
You get exactly 15 days. That's it. Section 2 is absolutely ruthless on this. The clock starts ticking the second you get that notice of judgment or the denial of your motion for reconsideration. And yeah, sure, you might get a 30-day extension for a really good reason, but you should treat that first 15-day deadline like it's your only lifeline. So here's the drill. As soon as that 15-day clock starts, you have to file the petition, and it has to be verified, you have to pay all the fees, and you have to serve copies to the lower court and to the other party. As Sections 1, 2, and 3 make crystal clear, if you miss even one of these steps, your petition could get tossed out before anyone even reads it. And Section 4 gives us this non-negotiable checklist. Think of this as your final gear check before you start the climb. You need every single thing on this list: the full names, the material dates that prove you're on time, your core legal arguments, a certified copy of the judgment you're appealing, and that incredibly important certification against forum shopping. There is zero room for error here. So you've done everything perfectly. You filed on time, your paperwork is flawless. Does that mean the Supreme Court is going to hear your case? Absolutely not. Now comes the hardest part of the climb, convincing the court that your case is so special, so important, that it's worth their time. This quote right here from Section 6 is really the heart of the matter. An appeal to the Supreme Court is not a right you can just demand. It's a privilege, and it's granted based on the court's sound judicial discretion. This just means you have to prove beyond a shadow of a doubt that your case has special and important reasons that make it worthy of review. So what in the world counts as a special reason? Well, Section 6 basically gives us the playbook. You need to ask yourself these questions. Did the lower court tackle a totally new, undecided question of law? Did its ruling go directly against existing Supreme Court decisions? Or did it just go completely off the rails and deviate from the normal way courts are supposed to act? These are the kinds of arguments that might, just might, get their attention.
Now, we need to talk about the dangers on this path, the common mistakes that cause even really experienced lawyers to slip and fall. So for all you bar reviewees and practitioners out there, listen up. These are the tripwires.
Section 5 basically lays out all the tripwires. Simple stuff like forgetting to pay the docket fees, that's an instant dismissal. But look at those last 2 points. Those are discretionary. The court can just toss your petition if they think it has no merit or that you're just trying to delay things or, and this is a big one, if the legal question you're raising just isn't important enough for them to spend time on. It's a crucial filter they use to manage their huge caseload.
And to really understand why the court is so incredibly strict, you have to get the doctrine of immutability of judgment. The idea is simple. At some point, a case has to end. It's for the sake of stability. Once a judgment becomes final, it's basically set in stone. Rule 45 is one of the very, very rare and extraordinary exceptions to that rule, and that's why the court guards it so fiercely.
Wow, we have covered a lot of ground on this climb. So let's take a quick pause near the summit and boil everything down into a simple, easy-to-remember cheat sheet. This is the stuff you absolutely need to burn into your memory.
Look, it all comes down to these 3 questions. What is it? An appeal on pure questions of law, period. When do you file? Within 15 days. And why will the court even look at it? Only if you have special and important reasons. If you remember absolutely nothing else from this, remember this table. What, when, and why.
And so we end right back where we started, looking all the way up at that summit. Filing a Rule 45 petition isn't just a procedural step, it's you making a bold claim that your legal issue is so important, so significant, that it deserves the Supreme Court's incredibly limited time and attention. So the final question you have to ask isn't just, can I file this? But rather, is my question of law truly important enough to justify the climb?